Herring v. United States, Supreme Court, 2009. Chief Justice Roberts delivered the opinion of the court. The Fourth Amendment forbids unreasonable searches and seizures, and this usually requires the police to have probable cause or a warrant before making an arrest. What if an officer reasonably believes there is an outstanding arrest warrant, but that belief turns out to be wrong because of a negligent bookkeeping error by another police employee? The parties here agree that the ensuing arrest is still a violation of the Fourth Amendment, but dispute whether contraband found during a search incident to that arrest must be excluded in a later prosecution. Our cases establish that such suppression is not an automatic consequence of a Fourth Amendment violation. Instead, the question turns on the culpability of the police and the potential of exclusion to deter wrongful police conduct. Here, the error was the result of isolated negligence attenuated from arrest. We hold that in these circumstances, the jury should not be barred from considering all the evidence. 1. On July 7, 2004, investigator Mark Anderson learned that Bernie Dean Herring had driven to the Coffee County Sheriff's Department to retrieve something from his impounded truck. Herring was no stranger to law enforcement, and Anderson asked the county's warrant clerk, Sandy Pope, to check for any outstanding warrants for Herring's arrest. When she found none, Anderson asked Pope to check with Sharon Morgan, her counterpart in neighboring Dale County. After checking Dale County's computer database, Morgan replied that there was an active arrest warrant for Herring's failure to appear on a felony charge. Pope relayed the information to Anderson and asked Morgan to fax over a copy of the warrant as confirmation. Anderson and a deputy followed Herring as he left the impound lot, pulled him over, and arrested him. A search incident to the arrest revealed methamphetamine in Herring's pocket and a pistol, which as a felon he could not possess, in his vehicle. There had, however, been a mistake about the warrant. The Dale County Sheriff's computer records are supposed to correspond to actual arrest warrants, which the office also maintains. But when Morgan went to the files to retrieve the actual warrant to fax to Pope, Morgan was unable to find it. She called a court clerk and learned that the warrant had been recalled 5 months earlier. Normally, when a warrant is recalled, the court clerk's office or a judge's chambers calls Morgan, who enters the information in the sheriff's computer database and disposes of the physical copy. For whatever reason, the information about the recall of the warrant for Herring did not appear in the database. Morgan immediately called Pope to alert her to the mix-up, and Pope contacted Anderson over a secure radio. This all unfolded in 10 to 15 minutes, but Herring had already been arrested and was found with the guns and drugs just a few hundred yards from the sheriff's office. Herring was indicted in the district court for the Middle District of Alabama for illegally possessing the gun and drugs, violations of 18 U.S.C. Section 922 G1 and 21 U.S.C. Section 884A. He moved to suppress the evidence on the ground that his initial arrest had been illegal because the warrant had been rescinded. 2. When a probable cause determination was based on reasonable but mistaken assumptions, the person subjected to a search or seizure has not necessarily been the victim of a constitutional violation. The very phrase probable cause confirms that the Fourth Amendment does not demand all possible precision, and whether the error can be traced to a mistake by a state actor or some other source may bear on the analysis. For purposes of deciding this case, however, we accept the parties' assumption that there was a Fourth Amendment violation. The issue is whether the exclusionary rule should be applied. Subsection A. The Fourth Amendment protects the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, but contains no provision expressly precluding the use of evidence obtained in violation of its commands. Nonetheless, our decisions establish an exclusionary rule that, when applicable, forbids the use of improperly obtained evidence at trial. We have stated that this judicially created rule is designed to safeguard Fourth Amendment rights generally through its deterrent effect. In analyzing the applicability of the rule, we must consider the actions of all the police officers involved. The Coffee County officers did nothing improper. Indeed, the error was noticed so quickly because Coffee County requested a faxed confirmation of the warrant. The 11th Circuit concluded, however, that somebody in Dale County should have updated the computer database to reflect the recall of the arrest warrant. The court also concluded that this error was negligent, but it did not find it to be reckless or deliberate. That fact is crucial to our holding that this error is not enough by itself to require the extreme sanction of exclusion. Subsection B. 1. The fact that a Fourth Amendment violation occurred, i.e., that a search or arrest was unreasonable, does not necessarily mean that the exclusionary rule applies. Indeed, exclusion has always been our last resort, not our first impulse, and our precedents establish important principles that constrain application of the exclusionary rule. First, the exclusionary rule is not an individual right that applies only where it results in appreciable deterrence. We have repeatedly rejected the argument that exclusion is a necessary consequence of a Fourth Amendment violation. Instead, we have focused on the efficacy of the rule in deterring Fourth Amendment violations in the future. In addition, the benefits of deterrence must outweigh the costs. We have never suggested that the exclusionary rule must apply in every circumstance in which it might provide marginal deterrence. To the extent that application of the exclusionary rule could provide some incremental deterrent, that possible benefit must be weighed against its substantial social costs. The principal cost of applying the rule is, of course, letting guilty and possibly dangerous defendants go free, something that offends basic concepts of the criminal justice system. The rule's costly toll upon truth-seeking and law enforcement objectives presents a high obstacle for those urging its application. These principles are reflected in the holding of Leon. When police act under a warrant that is invalid for lack of probable cause, the exclusionary rule does not apply if the police acted in objectively reasonable reliance on the subsequently invalidated search warrant. We, perhaps confusingly, called this objectively reasonable reliance good faith. Shortly thereafter, we extended these holdings to warrantless administrative searches performed in good faith reliance on a statute later declared unconstitutional. Finally, we applied this good faith rule to police who reasonably relied on mistaken information in a court's database that an arrest warrant was outstanding. We held that a mistake made by a judicial employee could not give rise to exclusion for 3 reasons. The exclusionary rule was crafted to curb police rather than judicial misconduct. Court employees were unlikely to try to subvert the Fourth Amendment, and, most important, there was no basis for believing that application of the exclusionary rule in those circumstances would have had significant effect in deterring the errors. Arizona v. Evans left unresolved whether the evidence should be suppressed if police personnel were responsible for that error, an issue not argued by the state in that case, but one that we now confront. 2. Anticipating the good faith exception to the exclusionary rule, Judge Friendly wrote that the beneficent aim of the exclusionary rule to deter police misconduct can be sufficiently accomplished by a practice outlawing evidence obtained by flagrant or deliberate violation of rights. The Bill of Rights is a code of criminal procedure. Oh, that was a citation. Indeed, the abuses that gave rise to the exclusionary rule features intentional conduct that was patently unconstitutional. 3. To trigger the exclusionary rule, police conduct must be sufficiently deliberate that exclusion can meaningfully deter it, and sufficiently culpable that such deterrence is worth the price paid by the justice system. As laid out in our cases, the exclusionary rule serves to deter deliberate, reckless, or grossly negligent conduct, or in some circumstances, recurring or systemic negligence. The error in this case does not rise to this level. The pertinent analysis of deterrence and culpability is objective, not an inquiry into the subjective awareness of arresting officers. We have already held that our good faith inquiry is confined to the objectively ascertainable question whether a reasonably well-trained officer would have known that the search was illegal in light of all of the circumstances. These circumstances frequently include a particular officer's knowledge and experience, but that does not make the test any more subjective than the one for probable cause, which looks to an officer's knowledge and experience, but not his subjective intent. 4. We do not suggest that all record-keeping errors by the police are immune from the exclusionary rule. In this case, however, the conduct at issue was not so objectively culpable as to require exclusion. In Leon, we held that the marginal or non-existent benefits produced by suppressing evidence obtained in objectively reasonable reliance on a subsequently invalidated search warrant cannot justify the substantial costs of exclusion. The same is true when evidence is obtained in objectively reasonable reliance on a subsequently recalled warrant. If the police had been shown to be reckless in maintaining a warrant system or to have knowingly made false entries to lay the groundwork for future false arrests, exclusion would certainly be justified under our cases, should such misconduct cause a Fourth Amendment violation. Petitioners' fears that our decision will cause police departments to deliberately keep their officers ignorant are thus unfounded. The dissent also adverts to the possible unreliability of a number of databases not relevant to this case. In a case where systemic errors were demonstrated, it might be reckless for officers to rely on an unreliable warrant system, but there is no evidence that errors in Dale County's system are routine or widespread. Petitioners claim that police negligence automatically triggers suppression cannot be squared with the principles underlying the exclusionary rule, as they have been explained in our cases. In light of our repeated holdings that the deterrent effect of suppression must be substantial and outweigh any harm to the justice system, we conclude that when police mistakes are the result of negligence, such as that described here, rather than systemic error or reckless disregard of constitutional requirements, any marginal deterrence does not pay its way. In such a case, the criminal should not go free because the constable has blundered.